The tourism and hospitality sector in both Namibia and South Africa is facing a sustainability crisis. Their losses deepen due to insurance companies rejecting or delaying valid claims related to the COVID-19 pandemic. When it comes to larger claims in Namibia, several insurers are fighting hard to limit quantum and the indemnity period for which they are liable. This interview aims to help Namibian policyholders understand some of the key issues.
We have seen most of the companies paying out to the policyholders or either offering settlements that are quite acceptable to some of the policyholders. But at the moment, the cases that are pending are cases where the policyholders have decided to hold the broker who was supposed to procure the insurance liable to pay. The cases were heard all the way to the Supreme Court of Appeal, and to date, the policyholders were always the successful parties in the litigation. At this stage, there are about 2 of our big insurance companies who are still not willing to pay out. However, there is no appeal at the moment. I think the closure of the borders was obviously not because of anything other than pure evidence that COVID would come into the country and would in fact create a disaster. So the borders were locked because of COVID. So COVID is the trigger event for the losses. That is the simple explanation. A legal precedent has definitely been set in South Africa. And I must just mention this, that until the 90s, Namibian judgments were also reported in South African law reports. And our laws are very similar. And therefore, I think that the precedent that has been created in our courts and the law that has been applied and the way in which it is applied to the COVID scenarios will apply in the Namibian courts in the same manner. We follow them because the English law is primarily the source of insurance law, and what happens in England directly reflects on the approaches that our courts might take in insurance cases. Let's first just quickly clarify how reinsurance works. Reinsurance is also insurance. This is where the primary or direct insurer who provides insurance to the policyholders, where that direct insurer takes out insurance for its obligations with a reinsurer. Your duty to pay your policyholder is not dependent on whether you get your money from your reinsurer. That is not an automatic provision. Only there where you have written it into that policy can you rely on that. So any broker or any company that says to Benny in Usakos, we can't pay you because our reinsurer did not pay out, therefore we don't owe you anything. That is blatantly incorrect. So the South African Financial Services Conduct Authority issued a few very valuable directives. The first, that property loss is not covered under BI, Business Interruption Insurance. So they clarified the issue on property damage or property loss, which the virus obviously does not cause, that is excluded. And then they issued another directive, which I have not seen in your law. It might have been given by your conduct authority, but that was that our insurers must consider intermediate relief. In other words, that our insurers pay some form of intermediate payments in order to tide over the businesses that are under severe stress, pending a future resolution of the disputes, of course. But our FSCA went one step further, and they said any interim relief that is paid out may be kept by the policyholder, irrespective of the final outcome of the case, of the dispute between the parties. Of course, insurance companies must remain solvent. That is of great concern, that they would go insolvent because of the massive load of business interruption claims. However, it was a first knee-jerk reaction that there would be massive insolvencies and liquidations of these firms or the companies, the insurance companies. It appears that many of the insurance companies have survived this rather well. The BI clauses, also in some questions that you directed to me via our email, are not always perpetual, and they are not unlimited. So very few insurers had to pay out business interruption claims that would last, for example, for 2 years and be of such great extent that they would literally close down the larger firms. Now, insurance depends on the fund, and members, by definition, cross-subsidize each other for covers of risk. So the premiums all go into the big pot, and everybody has an opportunity, providing that an event and a loss that they suffer falls within the parameters of the agreements, have a right to share in that specific pot of funding. So yes, it is the case that the bigger fund reserves now have to subsidize or pay the business interruption losses. However, that is the way in which the world works. If, for example, there is a sudden meteorite strike, then the victims of that deserve to be compensated from the fund, provided it is insured. So yes, the insurance companies are taking strain. However, a lot of them have reached agreements with their policyholders to pay the amounts to the policyholders over a longer time period, which then offers some form of temporary relief to the insurers, that they could postpone all of the responsibilities to pay over a longer period of time. And that, of course, is something that insurers should consider doing, helping out the policyholder and paying certain amounts over a time period. Well, if you think when COVID struck South Africa now, it was March, our big lockdown, 28 March 2020, and the litigation commenced against the insurance companies, big panic, solvency, etc. When it came to December 2020, the bonuses that were still paid out were a clear indication that the companies were not in such financial constraints as initially one thought they would be. So it has not been the biggest disaster for the solvency of insurance companies that was predicted. Not all BI claims have been paid out. Of course, there are still a lot of claims outstanding or pending. Each of these are separate entities, and they are not required to bail each other out. However, one would think that a larger company group would attempt its best at saving or salvaging one of the subsidiaries, rather than let them go down the tubes and pay out huge bonuses on holding company executives. I just found it extremely strange that if Hollard loses in South Africa, that they are still willing, on the same facts, on the same policy wordings, to resist claims and to actually get involved in litigation. That was strange to me, because I think if one of your subsidiaries has gone through the wheels, the others will also follow the same route. So opposing claims was for me a surprising move. I think irresponsible in a way, because of all the judgments in all of the countries that have gone against insurers, to still perpetuate litigation on the same scenarios, for me, is not best practice. What do I enjoy coverage for? The full year that the policy's entire validity is for, or only the 3 months for the business interruption or BI? And it is the latter one. The BI is usually also limited in time in the primary insurance policy, that one can only claim for a very short time period of losses, which sadly COVID has very often exceeded. What we saw immediately, of course, were changes of cover that insurers would mid-term, by notification of 30 days in, for example, a policy that would last 5 years, by 30-day notification withdraw business interruption cover. Now that's where our Financial Services Conduct Authority stepped in and specifically stated that no insurer may change these benefits during the existence of the policy without consulting with the FSCA. And that meant that there had to be consultation, there had to be, I suppose, indications of budgetary issues and of the fallout on policyholders. So that was very quickly in South Africa limited, and the insurers did not pursue that line very aggressively. The first thing is not to lose faith, because international judgments and South African judgments are in favor of the policyholder on the main turning point issues. The second point is form groups, join resources, and follow the procedures by approaching the financial service supervisory bodies, boards, councils, and approaching the courts then as a group, not a class action, not necessarily a designated class action. That takes a long time. But as groups of associations, for example, coming together.
If you have a story to tell, contact strings@netactive.co.za.